I've been practicing law in this area since prior to Y2K. Back in 1998, when I was in law school, a professor encouraged me to find an area of law that would be hot once I graduated. And so I chose Y2K, thinking that was going to be my rocket ship to stardom and that I would be retired well before now. As you can all see, I'm not retired, and as you all know, Y2K was not quite the event we thought it was going to be. And since then, I've tried talking to people over the years about cybersecurity, and until about 2014, I kept hearing, Shawn, we've heard this out of you before. But let me assure you, they're not saying that now. People are finally getting the message, and so it's nice to finally have a message that is resonating well with people. To further encourage you to take advantage of the social media opportunities that we have here today, I've got this little slide set up with the hashtag so you can all see it. I'm a big fan of social media and would love to see all of you join in. We have the SecureWorld Twitter handle up here as well as mine, and later towards the end of the presentation I'm sharing a couple of checklists via Twitter, so keep these on hand and go and look at the hashtag later, and you should get the checklist that I'm going to be sharing later. You know, to start, I know there are many of you probably sitting here thinking, why do I need to hear from a lawyer talking about cybersecurity? How many of you are thinking that? Come on, I know there's a bunch of you. I know you're thinking that. And for most of you that have worked with lawyers in the past, I'm sure there's a pretty good reason for that. But the point of my talk today is to help explain why cybersecurity is a legal issue. And as you saw popping up on the screen just now, all of these different companies that have had data breaches over the last couple of years, I want you to think about something. Think about why you know about these events that have happened to these companies. Why do you know about these cybersecurity incidents that these companies have had? Do you think it's because they're good corporate citizens and they just want to air their dirty laundry with the world? Or do you think there's another reason? Of course, there's another reason. It's called the law. The law mandates that they tell you about the problems they've had. The law mandates how they tell you, what they tell you, when they tell you. When they don't have to tell you, certain exceptions. These are all legal issues. The law mandates how companies protect your data, or how you as companies protect other people's data in many cases. Oftentimes we don't know about these because they get buried in other laws and other policy discussions. But cybersecurity is absolutely a legal issue. And over the years I've been thinking about this, and I've come up with the little saying that security and IT protect companies' data. Legal protects companies from their data. Now, what do I mean by that? Okay, in today's world, data is like a hot potato. Nobody wants it. Nobody knows what to do with it. It creates all kinds of liability and problems for companies. And when you don't protect it and something bad happens to it, then it's a legal issue for sure. The company has to deal with it. And it's usually legal within the company that does have to deal with it. Think about the liability that comes from data. Okay, cybersecurity and data breach. Out of all my years of practicing law, this is the only area of law that I know of where the company that in most cases is the victim of some form of an attack, whether it's from the outside or the inside, or the victim of some kind of negligent behavior, becomes the wrongdoer over the course of time in the eyes of public policy and perception and in the eyes of the law. Think about it. How many other areas of law and public policy do you know of where the entity that was attacked becomes the wrongdoer? That's what we see now in public perception with cybersecurity and with legal implications. And so our job in legal is to help protect the company from the problems that come about with not securely protecting data and networks. The other little saying that I can't take original credit for, though I don't know who really came up with it, but it's that cybersecurity is no longer just an IT issue. It's now a business risk issue that has an overall impact on the business, from marketing all the way down to the more traditional areas of risk management, and from people sitting at their desks, hopefully learning to avoid phishing emails, all the way up to the boardroom. It is a business risk issue, and it requires having everybody having a seat at the table to adequately address it. There's no one specific sector within the companies anymore that owns cybersecurity. Everybody needs to have a part in it now because it impacts everybody within the organization. So where do our legal obligations come from? First, I want to talk a little bit about the three different types of legal obligations that you see dealing with cybersecurity. One are the security laws. Now, many of you may not know this, but there are a lot of different states, as well as federal regulatory agencies, that have specific laws mandating how you must protect the data within your networks, how you must protect your networks. Now, usually they're very vague in general and state something like, must use reasonable means to protect the data, or, take reasonable precautions, something like that, but they're there. And some states are now starting to find those and pull them out and say, aha, you didn't do this. It wasn't very specific, it hasn't been publicized a whole lot, but they're there. Usually they're buried behind the privacy laws, okay? 48 states currently have laws that require notification to individuals when their information has been compromised. These focus on the privacy aspect. They don't, in a true sense, mandate how to protect the data, or even that you do protect the data, though they're sometimes coupled with the security law. But they say if there is a lapse or a breach, you have to notify people that their information has been compromised because there's been a breach of their privacy, and we want to alert them so that they can go protect themselves in the event someone's taken their information and using it improperly. These are privacy laws. Then we have the unauthorized access laws. Many of you have probably heard of the Computer Fraud and Abuse Act. That's the federal law that prohibits improper use, improper access to a computer, what most refer to as hacking. Okay, in Texas, we have a very robust unauthorized access law. It's called Breach of Computer Security. And it goes a little farther than the Computer Fraud and Abuse Act. These are the laws we use in that rare case when you can attribute who did it, go get them, bring them back, and prosecute them. These are the kind of laws you use. More frequently, we see them used in the civil context where I deal with them, when you have insiders who are misusing their access to data in the networks. These laws come into play many times. So there's three different types to think about, and they can come from international sources, such as what we used to see with the EU Safe Harbor regulation. Now that's gone, and we see the privacy shield in its place. You have excuse me, the GDPR, the General Data Protection Regulation that I'm sure all of you are very familiar with. If you aren't, I hope you attended Kathy Britton's session an hour ago talking about the GDPR, because the organizers of SecureWorld were wise enough to see just how important this issue is and devote a session to it. And hopefully, if you weren't able to attend it, you'll at least be able to get the slides to it, because this is a huge issue that's going to have a huge impact on how you do business, even if you're not operating in the EU, because you may be doing business with people, with companies that are, and therefore you're going to be subject to a lot of these requirements through your contracts. We have federal laws and regulations. Most of you are familiar with HIPAA, okay? HIPAA actually incorporates both the security and privacy aspects when it comes to data, mandating how it is to be secured and what you have to do in the event of a privacy breach. There's Gramm-Leach-Bliley. There's the federal education protection regulation. There's all kinds of regulation out there now from the FTC. The Securities and Exchange Commission is getting into it, and the Federal Communications Commission. Okay, they have a lot of different sources of regulation that has the effect of law and that must be complied with. And then there's the state laws. As I mentioned, we have 48 states right now that have their own breach notification laws. I also mentioned that there are many other states that have a security component within them. Right now, New York, through the New York Department of Financial Services Cybersecurity regulation, has put out 19 pages of specific requirements companies must go through on securing data and how to go about it. Colorado saw this and said, well, we want to be a part of this also. And so they've put out their own regulation for the financial services industry within Colorado. Now, let me ask you something. For all of you who are involved in security, and I'm sure most of you are, what's going to happen when we have 48 states publicizing and promulgating their own 19-page regulation on how you have to comply with data security within to do business in their state? All the breach notification laws do not match up nicely. Most do, but not all. There's a race amongst the legislatures to see who can do something, who can act, who can show they care by passing a new, more stringent regulation or law. We're going to see that happen with cybersecurity requirements, with the security aspect. And it's going to be chaos for business. So because of that, there's been a push for a national breach notification law. And I was in Congress last May to talk about that and did not get a very warm reception. Not because all of the congressmen didn't agree that it was a great idea. It was because of this committee issue that I wasn't understanding well enough prior to these visits that I understand better now. But after the Equifax breach, we've heard a lot more talk about a national breach notification law. And a lot of people are now talking about throwing in cybersecurity with it because they're not appreciating the distinction between the privacy aspect of a breach notification law, which says if you screw up and let somebody's data out into the wild, you've got to tell them about it, versus the security aspect of mandating what a company must do to protect their networks and their data. They're jumbling it all together. And they're saying, yes, it's a great idea, let's do it. And few people are seeing that little fine point. But it's something that we need to understand and recognize, because a lot of the bad stuff we hear about the laws, you know, when you read Facebook and all the experts and even Twitter sometimes, is people get confused on some of these finer points and they just jumble it all together. and they don't understand just how significant the fine point is between having a national breach notification requirement versus a national cybersecurity requirement. So keep your eyes open and pay attention. We also have industry groups. Most of you are familiar with PCI and how strong the requirements are there and the enforcement provisions. We have FINRA, we have other organizations out there that deal with cybersecurity and data protection in general. And then the one most people seem to forget about. Their contracts. I see more cybersecurity law in the form of contracts these days than I do anywhere else. Because a contract is simply the law between the parties. It's what the parties agree to will be their law governing their relationship. And we see all kinds of contracts now that, have some general counsel somewhere that's never dealt with cybersecurity, or some CFO who thinks it's a good idea to slap on the old privacy addendum to their master services agreement, and nobody ever reads them to pay attention and see what's really in them. What do they really mean? What are they really doing and requiring? There are contracts all over the place that have very specific requirements concerning the privacy aspects, the notice, giving notice to your business partner if an incident has happened, and the mandates on how to protect it, on requirements for certain levels of security in certain places. Unfortunately, most people just sign these things without thinking about it. And then there's this little right to audit that shows up at some point, and a knowledgeable party shows up to audit the security of the other party, and they go, well, wait a minute, what are you doing here? You can't come look at our system and audit us. And they say, well, sure we can. It's in the contract you signed. Go look. And then they panic and call me and say, oh my God, how do we get out of this? I say, well, it would have been better to have not gotten into it if you didn't know what you were doing, or put a plan in place and do it the right way, because there's a good reason for all of this, third-party risk. So I hope you get the point that this is definitely a legal issue. And my point in telling you all of this is because I recognize the realities of what you are all dealing with when you go back to your companies. Look, my practice is made up of three components. One, incident response, breach response. About 70% of my work is breach response work. 20% is this fruitless effort to try to get businesses to implement and mature a cyber risk management program that helps eliminate or mitigate some of these legal issues. Okay, I say 20% because of all the people I encourage to try to do something proactively, they never want to. They never step out. I know what you guys are dealing with because I deal with it too. But when you're able to share information with your CEO, or if you report to the board or whomever you report to, and talk to them about these legal issues, a lot of times it does help. It helps you get more of what you need to better do your job. And so I'm not trying to scare people, but enforcement's picking up. We haven't seen a lot out of the Texas Attorney General, but I was able to visit with the attorney in charge of data protection last week, and I have every reason to believe we're going to see a whole lot more, and a lot of what they've been doing hasn't been publicized, so we just haven't been aware of it. This is a trend nationwide. And so that's my point, but my point's not to scare you, because in my experience, what I've seen over the years is that we can manage most of these risks. Not all of them, probably, but most. And when you look at the findings of the Online Trust Alliance reports each year that come out and show that 90% on average of the incidents that happen, of the breaches that happen, I should say, were not the ultra sophisticated James Bond, the Russians did it kind of stuff. They're failures of basic cyber hygiene. Those are the kind of things we can improve upon and we can teach and train. And so my experience in handling incidents for companies is consistent with that. Most of the incidents we handle, whether it's little small companies, healthcare providers, or big enterprise level, organizations, they usually start from a failure of something simple. Most often it's email, it's phishing, it's passwords. I can't tell you how many lost thumb drive cases I've had to do breach responses on. That's not the kind of stuff that we can't teach and train and get better with. And so I see there being a lot of hope here as well. And from a legal and regulatory standpoint, I've gone and looked at a lot of the decisions that have been handed down over the years to see what are the regulators focusing on, what are the judges and the courts focusing on. And it's consistent with what I just mentioned. They're not looking and holding companies to the highest standard out there, because that's not where most of the problems come from. They're trying to get the companies on the bottom to up their game, to become better and have more good basic cyber hygiene in place and defenses within their networks. And I think that's positive. And I also think that's positive when I look at many of the programs that SecureWorld has going on right here. There's a lot of focus on implementing what many people here consider the basics. And when I sit down and look, I came up with what I see are many of the cybersecurity best practices on this slide. And look, everybody has their opinion of best practices. I get it. I'm just a lawyer. I get that as well. But looking at smart friends and borrowing from them, I think there's quite a few of them on here that we view as best practices. And so comparing these to many of the regulatory decisions, I've tinkered with the slides a little bit, and I want to ask you this. How many of you in here can tell me that your company has reasonable cybersecurity? You all know what reasonable cybersecurity is, right? Who knows? What is reasonable cybersecurity? That's what Target responded to the court with in the financial services litigation and said, Judge, we've done this, we've done this, we've done this. We were reasonable. And the court didn't find that they were. In the Wyndham case that went all the way to the Third Circuit Court of Appeals, this is a great example of how do you define what is reasonable. Wyndham had 3 breaches within a very short period of time, and the FTC lodged an enforcement action against him, and it ultimately got appealed to the Third Circuit, and the FTC said, excuse me, Wyndham, you did not have reasonable cybersecurity practices. And Wyndham said, how are we supposed to know what is reasonable? And the FTC said, well, back in 2007, we put a little guide on our website that outlined the things you should be doing. And you didn't do those. You should have known that guide was there. You should have gone to our website. You should have done this. And the court agreed with them. So what is reasonable? We don't know what reasonable is. Someone could argue that all of these things are reasonable. But the important point that I've taken away from all of this, from a legal standpoint, is the number one thing you have to show is that as an organization you care and that you really tried. Okay? I know J.P. Hill's going to be speaking on security versus compliance later here. You know, it's not a matter of just checking the boxes. It's a matter of showing you really tried and you did your best, even if it wasn't good enough. And I often think, if I were CEO of a company and I was hiring someone to be the CISO, what's an important trait I would look for in them? And you know what one of them would be? How many conferences like this do they ask me to go to? Because see, y'all aren't the problem. Y'all care. Y'all want to learn. Y'all want to be involved. You want your companies to do it right. That's why you're willing to take time out of your day to come here to an event like this to learn. But do you think everybody in your industry is like that? Or that there are some folks who, like Fred Flintstone on a Friday afternoon at 5, want to hit the old dinosaur. You know, it's over, I'll be back on Monday, whatever happens till then, I'm off the clock. Most of the really bad incidents I deal with, that's the kind of people that were in charge. They may have had great qualifications, but they didn't really care. And you could tell in every aspect of how they ran security within their organization. Regulators have learned how to tell that also. And they can sense that. They can see it through conversations and through meetings and through phone calls. You know, they can tell how seriously you take it within your organization. And so, you know, for those of you that are here, all of you, I guess, it's a dumb lawyer statement, keep taking it seriously and keep showing that you care. But make sure you have these little basics in place. Does your company have adequate internal network controls? Think about how you would answer that question. There was a case involving LabMD a couple of years ago that's still going on, that was brought about, ultimately put the company out of business through an FTC enforcement action. And it was because one employee out of a company of about 25 in a cancer research facility, one employee was using LimeWire. Now, none of y'all have ever used that, right? Y'all don't even know what it is, huh? And certainly nobody within your organization could have that on the network, right? Well, in this case, one employee did, and had that little peer-to-peer file sharing folder set up without knowing what they were doing. They just wanted free music. And it inadvertently made available a list of patient accounts receivables of 1,900 some odd patients. It never got distributed, never got blasted out of the network. A cybersecurity firm called Traversa had found a unique business model of trolling these sites, basically, and then going in and looking to see what they could find. They found this through LimeWire, and then contacted LabMD and said, hey, for 25 grand or something like that, I don't remember the exact amount, we'll tell you where we found it, and we'll tell you how to protect yourself from it. And LabMD responded in a way I'm not going to repeat up here. And Traversa said, okay, fine, we'll turn it over to the FTC, and sent it to the FTC, and the FTC picked it up from there. This is an outlier case. You don't see many like this, but it's possible. And it also shows just how important having control over what is on your network is. Whether, it's your network. You're responsible for it. You're responsible for that data. And saying the employee did it is not a good excuse. The old dog ate my homework type excuse. It doesn't fly. So what do you need to have? You need to have, and you go through this opinion in this. It was a 96-page opinion, the order. And they looked for things like policies and procedures focused on cybersecurity, training of the workforce to make sure they not only signed the policy, but understood the policy and understood why the policy was there, usually through examples such as I just described. And then having access controls to ensure that things like this couldn't be uploaded and put on the network. Does your company have written policies and procedures focused on cybersecurity? This sounds like a no-brainer, right? Maybe to you it is, but to most of the business community, not even close. They find some, we sell policies and procedures, pay $500 here and get your forms and fill them out. And they do it, sign it, say we did training, and they think it's never going to come up again. Wrong. The first line of defense is teaching and training your people. You train them through your policies and procedures initially. And if your policies and procedures aren't suitable for training your people on real threats, then you need better policies and procedures because they're meaningless if they're not useful for that. And that training aspect is critical. I love to take the policies and procedures and sit down in a 1-hour training with a videographer for future onboarding with a select group of employees or however many we can get into a room and walk them through this and explain to them why we say things like, don't pick up a USB drive out of the parking lot and come plug it in. Or don't use 8675309 as your password. How many of y'all know that one? Good. I've got some fellow 80s brothers and sisters here. But people aren't clairvoyant. They're not reading this stuff on the weekends and educating themselves. It's up to you to do it. And you start by doing things like this. People don't want to do stupid things at work. Most of the times it's just because they don't know, because they haven't been properly trained. Your policies and procedures are the foundation for that. Doesn't mean you don't start doing more, but you start with that. And in the case of R.T. Jones, where the SEC came after them, that's what the SEC found. They said, you didn't have appropriate policies and procedures in place. You didn't train the workforce on them. That tells us you didn't really care about protecting your network or your customers' data. Okay? Same case, does your company have a written cybersecurity incident response plan? And I don't care what you call it. There's many different names for it. But you know what it is and you know what it does. In this case, the SEC said, you obviously didn't care about your customers' data in the event of an incident happening because you didn't even put a plan in place for how you would deal with such an event. Look, what's the magic to creating an incident response plan? I have no idea. I've created a few. I've tried. Every time I do it, they evolve quite a bit. I know we have several sessions here talking about creating or developing incident response plans and developing cybersecurity plans in general. The point is you have to go through the process and you have to show your work. You have to document your decisions and you have to document why you're doing it and what you're doing and everything else. because that's how you show you really care. And if you really care, you will do this. How does your company manage third-party cyber risk? Now we're getting a little tougher, huh? Hopefully, this, third-party cyber risk has kind of been a buzzword this year. Hopefully we're all paying attention to it and getting better at it. But how much are we really? Whether we're the small company doing work with the really big one, or we're the really big one entrusting our most precious data into the hands of some little company that's total net worth is less than our security budget. Yet we're trusting our most sensitive intellectual property into their hands and assuming they're going to do a good job of protecting it. It's not that they don't want to. It may not be that they don't know how to. They may not be able to afford to. But you better find that out at the beginning of the relationship, not after it's too late. Your data, your IP, your customer data, when it loses its value from being breached, it doesn't matter if it came from you or somebody else. It's gone. It's like the balloon getting pricked. It's over. You have a duty to investigate the security of companies you do business with. You have a duty to obligate them through your contracts to maintain certain standards. And you have a duty to audit them. At least that's what the FTC said in the case of GMR transcription services, when it found this company did not do that and forced them into a 20-year consent decree. They're doing it now, and the FTC is the one obligating them. Okay? These are the kind of things that you can do. How mature is your company's cyber risk management program? How many of you have seen this one? It took me quite a few reads of this opinion before this jumped out at me. But in the GMR transcription case and in several others, the FTC is now requiring a full-fledged cyber risk management program that takes into account everything we've been talking about. All of these little sub-issues. Okay? Then look at New York. The New York Department of Financial Services regulation. And if you don't know whether this impacts you or not, you need to find out, because it may very well. Even if you're not a New York company, you need to look at this. But it requires establishing a cybersecurity program. And it needs to be comprehensive, and it requires a whole lot of other things. But one thing we do know is the foundation of all of them have to be a risk assessment, because there's no one-size-fits-all, check-the-box way of going about it. Every company's risk is unique. And the way you defend against it has to be unique as well. Then you look at the EU General Data Protection Regulation. There's all kinds of stuff in there. Just reading it is insane, much less trying to comprehend all of it. You need to be paying attention to this one, because to comply with all of this, you're going to need a good cyber risk management program in place. And over the years, I've come up with the processes that I've seen that need to be in place. And like I said, it starts with the risk assessment. Because when you can show those regulators, judges, plaintiffs' lawyers, that you really dug in and tried to learn where your company's exposure was, and then develop a custom plan in response to that, and then actually go through the process, take the steps to do it, you really separate yourself from the crowd of all these other companies that are getting breached right now. I mean, think of Equifax at this very moment. How valuable would it be for them to be able to explain to Congress their program for patch management? and how they went through it and how they developed this program and how they educated the people responsible for it. And then if they got it wrong, okay, we all make mistakes, but by God, we did the best we could. That's a pretty good position to be in these days. But just saying we made a mistake, we're sorry, people aren't sympathetic to that. You got to show your work. You got to show you cared. And I'm going to skip a couple of slides here because my time is almost up. And I don't want Carrie to come tackle me from over there. My incident response checklist. I told you I tweeted something out. Y'all didn't see me up here, right? This is when I was pausing for the water. But no, go to Twitter. This is a data breach incident response checklist. I know most of you probably know what's in here, but it's something you can download, you can show to people within your organization to say, look, if we have an incident, these are the kind of things we have to do, all of them, within sometimes a matter of hours, at most a matter of days. We can't do this if we're not prepared for it. We need to get prepared now. And this is how you can show the justification, because most people do not realize what goes in to an incident response like this. And finally, I'm going to close with this. Get a little philosophical here on you. Think about this. You do not drown by falling into the water. You drown by staying there. Now, how does that apply to security? It's what I've been telling you all along. Incidents happen. Problems happen. Things happen. But when you're prepared for them, they're not catastrophic. They're not fatal to your organization. Many times, most of the incidents I see that we have major breaches could have been managed early on if someone had been a little more proactive and prepared. But they weren't. And then it spirals out of control. And so my challenge for all of you is do the best you can. Show your work. Be prepared to show that you really care. And when that incident happens, that you're ready to respond and ready to manage it appropriately. And so I've used up all my time. So I don't have time for questions, but anybody that wants to chat, please feel free to just track me down. I've got the afternoon open. So thank y'all very much.
Shawn, thank you very much. Great stuff.